Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Naim Hazim and we are representing the appellant Brown in this case. The question presented is firstly whether the learned High Court judge has erred in fact and law on his finding that the communication of acceptance was completed, thus binding the appellant to the contract under Section 4 and Section 7 of the Contract Act 1950. And the second one is whether the learned High Court judge has erred in fact and law on his finding that the valid contract by way of misrepresentation gave rise to the presumption of voidable contract under Section 19, Clause 2 of the Contract Act 1950. If you please, if it please the Lordship, the appellant has presented a counter offer to respondent for selling the limited edition Roadmaster 2000, which was offered by the respondent for RM 3,000 ringgit. The counter offer was made by the counter offer was made by the appellant for RM 2,000 ringgit. The counter offer was made via phone call, and the respondent did not provide his acceptance immediately and instead went on a vacation where he gave his acceptance via a postcard and did not notify the appellant via any other method of his acceptance. Before the postcard arrived, the appellant decided to withdraw the counteroffer and made such withdrawal via leaving a message on his answering machine. The respondent then went to the appellant house to deliver the bike to the appellant, where the appellant refused to pay for the bike. The bike was left there by the respondent at the appellant's house, where it is found out that the bike was not, in fact, a limited edition Roadmaster 2000, as was claimed and advertised by the respondent in his offer. The respondent takes sue the appellant for damages. The land judge allowed the appellant claims against the respondent for the sum to be paid together with costs and interest, stating that there was a valid contract between the respondent and the appellant from the moment the respondent had posted the postcard, which was before the appellant purported withdrawal of the offer. The appellant is unsatisfied with the judgment of the Land High Court judge, hence this appeal. My lord, the appellant of this case shall now direct the attention of the Honorable Judge to the first ground of appeal. The first issue is that the learned High Court judge has erred in fact and law on his finding that the communication of acceptance was completed, thus binding the appellant to the contract under Section 4 and Section 7 of the Contract Act 1950. The aforesaid ground is hinged and built based on the line of issues which shall be discussed hereinafter to substantiate that the appellant is able to assist the Honorable Judge on the position of current law under Section 4 and Section 7 of the Contract Act. The acceptance of the contract are not communicated in line with Section 4 and Section 7 of the Contract Act. My Lord, Section 4, Clause 2, Clause A of the Contract Act states that the communication of acceptance is complete against the proposer when it is put in a course of transmission to him. In addition, Section 4, Clause 2, Clause B of the Contract Act further states that the communication of an acceptance is complete as against the acceptor only by when it comes to the knowledge of the proposer. Section 7, Clause A, on the other hand, provides that an acceptance must be unconditional, absent to terms proposed in the offer, which was principle stated in the case of Kawah Bank Limited and versus Nadirusa Sdn Bhd and another, where the federal court states as follows: according to the Treaty on Contract 27th edition, an acceptance is final and unqualified expression of assent to the terms of the offer, but where the reply is qualified attempts to vary the terms or offer or attempts to accept an offer on new terms, then such reply is not communication of acceptance, but may be a rejection accompanied by a counteroffer which the original offerer can accept or reject. My lord, Next, I will highlight Section 7, Clause B of the Contract Act, which provides that where the mode of acceptance is specified in the offer, the acceptor must communicate his acceptance in that mode. If no mode is specified, acceptance by any usual reasonable manner which shows the acceptor's intention to accept is sufficient. However, in the case of Prism Leisure versus Lumut Marine Resort, Judge Malik Ishaq Jain appeared to suggest that the offerer must know that his offer has been accepted in order for the contract to be constituted, by saying it must be recalled that the plaintiff had communicated its acceptance of the defendant's offer in writing, that the communication constitute a valid contract. In short, an acceptable an acceptance must be communicated to the offerer. Thus, there would there would not be a contract when a person writes an acceptance on a piece of paper and keep that piece of paper to himself. Similarly, when a company resolves to accept an application for shares but fails to communicate the resolution to the application to the applicant, there would not be a contract in existence. The offerer must know that his offer has been accepted. It would cause hardship to the offerer to be bound without knowing that his offer has been accepted. Here, the letter of acceptance was in response to the letter of offer and was communicated to the defendant. That will be sufficient to constitute a valid, legal, and binding contract between the parties. It was in his judgment, and he held so accordingly. In the case of Ramakrishnan Chelaya versus Lord Chemical Titan Holding Berhad and another, Azizul Azmi in his judgment states that in his judgment, if a true construction of Section 7 Clause B, an offerer who never received a non-conforming acceptance is not bound by that acceptance, it must also follows that Section 4, Clause 2, Clause A is subject to the implied terms that an acceptance binds the offerer from the time it is dispatched only if the acceptance eventually reaches the offerer. The common thread in these two conclusions is that an offerer cannot be held to a bargain which he knows nothing. My lord, the general rule is that the acceptance is completed when it is brought to the notice of the appellant, which the respondent had failed to do. However, the exception to such general rule is found in the postal rule, which stipulates that the acceptance is completed when the postcard containing such acceptance is posted. The postal rule, however, cannot be applied in cases where the acceptance is made by post. It can only be applied where it is specified that the acceptance made by way of post or where it is reasonable to post the acceptance, such where the offer itself was sent by post. Thus, in this particular case, the communication of acceptance via postcard, which was made by the respondent, should not be applied to the counteroffer that was made by the appellant, which was in fact made via phone call, and he did not specify that the acceptance should only be made through postcard. In this current case, my lord, the appellant humbly submits that the appellant had not received notice of the communication of acceptance made by the respondent, thus making the acceptance as not in line with Section 7, Clause A of the Contract Act, which requires the acceptance to be absolute and unqualified. The respondent did not provide his acceptance to the counteroffer, which made by the appellant immediately, and instead opted to withhold his acceptance and delivered his acceptance via post, which in no way whatsoever has been communicated as the only way his acceptance to be communicated. The appellant was not made aware of the respondent's acceptance in the manner where the the counter offer was first offered, which is via phone call. Thus, the appellant should not be bound to the respondent's acceptance to the counter offer. In addition, the postal rule shall not apply to this current case, as the circumstances of this case is that the communication of acceptance via post is not a requirement, and even is not a reasonable method of communicating the respondent's acceptance to the counter offer, as the counter offer was instead made via phone call by the appellant, which allows immediate interaction. Apart from that, the appellant did not specify the acceptance should be made via post, which makes the communication of acceptance as a communication that is not reasonable. In short, the contract should not bind the appellant until the appellant was given notice of acceptance. My lord, the appellant shall now proceed to the second issue, which shall be presented and be represented by my colleague. Thank you.
Okay, now I will continue with our second ground, that is the learned High Court judge erred on fact and law on his finding that there was a valid contract by way of misrepresentation to give rise to the presumption of voidable contract under Section 19, subsection 2 of the Contract Act 1915. The aforesaid ground of appeal is revolved and rested upon the position of law under Section 19 of the Contract Act, which shall be further elaborated hereinafter so to assist the Honourable Judge and eventually allowing this appeal. The validity of the contract built on false representation under Section 19 of the Contract Act ensure the damages be rewarded to the innocent party, which is the appellant. My lord, the validity of the contract built upon false representation, the learned judge has ruled that there was a valid contract despite the false representation made by the respondent of this case, which is the appellant belief. The law has been misjudged. In the case of Abdul Razak bin Datuk Abu Samah against Shah Alam Property Sdn Berhad and another, the misrepresentation in turn are three types depending upon the state of the mind of the maker. The state of mind may be fraudulent, negligent, or innocent in the sense that it is truly free of any blameworthiness or inadvertence. In the same case, it is further stated that fraudulent or negligent misrepresentation renders a contract voidable at the instance of the representee. In the present case, the appellant firmly believed that the appellant was induced to enter into the contract based on the misrepresentation made by the respondent, which is likely not merely an innocent misrepresentation. As quoted in the previous mentioned case of Abdul Razak Abu Samah, the degree of misrepresentation depending on the state of mind of the maker. In the present case, the appellant entered into a contract to purchase the bike under the impression that the bike was the limited edition as advertised by the respondent. In this situation, the respondent as the seller sure has the knowledge in regards of the bike. The respondent has admitted either negligence or fraudulent misrepresentation. In the case of Lim Siu Lan against Pembangunan Hisham Sdn Berhad and another, it was held that the representation made in the brochure, which is not fulfilled, indeed lead to misrepresentation. In the case of Bonti Dynamics Sdn Berhad against Chow Tat Min and 175 others, also cited the same principle that a misrepresentation may lead one into executing sale and purchase agreement. Both cases has ruled that a contract entered by misrepresentation are voidable contract. The validity of contract would be questionable as the contract entered by way of misrepresentation may cause injustice to a party of the contract. As for the regards of damages to be rewarded, in the case of Hadley Bryan and Co. Limited against Heller and Partners, it was ruled out that if misrepresentation was made negligently, the remedy of representee lies in damages. In Sim Tong Realty Sdn Berhad against Teh Kim Dar, if the misrepresentation is made fraudulently, then the representee is entitled to rescission and all damages directly flowing from the fraudulent inducement. My lord, the state mind of the person to produce any representation was indeed a complex matter which need a very detailed judgment by law. I humbly request your lordship to determine the state of mind of respondent in this present case in advertising the subject of this case, the bite which inducing the appellant to enter an agreement to purchase the bite. However, I firmly stand on our ground that the respondent has admitted misrepresentation, which is not equally to innocent misrepresentation. In the case of Low Court Fight against Port Klang Golf Resort, Sdn. Bhd, damages may be granted to the innocent representee that was induced to enter into a contract by false representation. The case of Abdul Razak Abu Samah against Shah Alam Properties Sdn. Bhd, damages are awarded for the fraudulent misrepresentation. In this current case, the appellant humbly submits that it is not the intention of ours into saying that the judgment given by the previous learned judge are completely error in law by allowing that there was a valid contract. However, there might be a mishap admitted in relaying the judgment. I believe that the judgment was inadequate in favour of the appellant, whereas no damages awarded to him despite the false representation made by the respondent. Now I will pass to the next counsel.
In conclusion, the appellant humbly submit that the appellant in this case has been highly prejudiced. Therefore, in the light of fact established, issue raised in argument advanced, the appellant respectfully requests that the Honourable Judge, in allowing the appeal of the appellant which goes on the ground that the learned High Court Judge erred in fact and law on his finding that the communication of acceptance was completed, thus binding the appellant to the contract under Section 4 and Section 7 of the Contract Act 1950, and the Learned High Court Judge erred in fact and law on his finding that the valid contract by way of misrepresentation gave rise to the presumption of voidable contract under Section 19 subsection 2 of the Contract Act 1950.